Hello there, I'm Terry Gorry. I'm a solicitor and I do quite a bit of employment law. Are you getting the rest breaks in work that you're entitled to? Or are you unsure or unclear about the rest breaks that you are entitled to? In this video, I'm just going to take a look at what you as an employee are entitled to by way of rest breaks in work. The relevant legislation is the Organisation of Working Time Act 1997. It sets out minimum rest periods over a daily period, weekly period, and so on. Section 11 of the Act stipulates that an employee is entitled to a rest break of not less than 11 consecutive hours in each period of 24 hours. This is the daily rest period. Section 12 then states that an employee is entitled to a rest period of at least 15 minutes after working for 4.5 hours and a break of at least 30 minutes after working for 6 hours. A break at the end of the working day is not acceptable and does not comply with the Act. The 15-minute break can be included in the 30-minute break, but would obviously have to start no later than 4 hours and 30 minutes after the commencement of work. Section 13 then deals with weekly rest periods and gives an entitlement to at least 24 consecutive hours of a break in each period of 7 days, or at the employer's discretion 2 rest periods, each of which must be for at least 24 consecutive hours during a second 7 days period. There are special rules also for retail workers. For any shop employee whose hours of work include the hours from 11:30 a.m. to 2:30 p.m. and who works for more than 6 hours, the minimum duration of the break shall be 1 hour. This 1 hour break shall take place between the hours mentioned and cannot be granted at the end of the working day. Section 14 then of the Act provides for compensation for workers who work on Sundays. However, the employer can argue that the computation of the employee's pay has already taken into account working on Sunday and given them a premium or an allowance for that. If that's acceptable to the WRC or whoever, well, that's the end of it. The employer can do that. Section 15 then deals with weekly working hours and states the employee cannot work in excess of an average of 48 hours in a week. Now, the average is taken over a 2 to 12 month period depending on the industry and whether you're a night worker or not. The Organisation of Working Time Act 1997 also offers extra protection for night workers. Section 16 and deals with night workers, and we won't go into the exact details here. Certain sectors of activity then are exempt from the provisions of the Organisation of Working Time Act 1997 and have their own special regulations. For example, the transport sector. If your rights are being breached or not upheld, you're not getting your breaks, you can bring a complaint. You used to be able to bring it to the Rights Commissioner. The Rights Commissioner service has been replaced by the Workplace Relations Commission. Now, you can bring your claim to the Workplace Relations Commission and he or she can find that your complaint is not valid or uphold it and order the employer to recognise that that your rights have been breached and to order rectification, or depending on the circumstances of the case, can order up to 2 years' salary to be paid for a breach of any provision of the Organisation of Working Time Act 1997.